Everybody's ready, so we can move forward. All right. This is, all right. Opening the Selma City Council special meeting, January 14th, 2021. Selma City Council Chambers, 1710 Tucker Street, Selma, California, 93662. The teleconference phone number is 1-301-715-8592. The ID is 832-1391-0996 with a password of 2021. This meeting is being conducted in accordance with the COVID-19 virus guidelines. Anyone appearing at the meeting is going to be asked to appear telephonically rather than in person. And with that, we will move on to roll call. Call the roll, please.
Councilmember Guerra.
Here.
Councilmember Mendoza Navarro. Here. Councilmember Trujillo.
Here.
Mayor Pro Tem Cho. Mayor Robertson.
Here. Potential conflicts of interest. Any council member has a potential conflict of interest may announce the item now and recuse themselves from discussing or voting on the matter.
Mr. Mayor, may I approach and address the council on the matter of conflicts of interest?
Yes.
My obligation under the professional rules of conduct is to alert this council whenever I see one or more of you out to do something or fail to do something that violates the law and tell you what the consequences are likely to be and attempt to deter the violation. I would be remiss in my obligations if I did not point out what I have attempted to point out in a memorandum that I've issued. Hopefully you've had a chance to review that. If you have not, I would, if you're not willing to do that, then I would suggest that one council person during your December 7th meeting in closed session made a complaint to me. And that was that council person's first meeting. The council person has no personal knowledge of me or what it is in the past. And the complaint, you will remember, Mr. Mayor, is the very same complaint that was leveled by a former council person against me. It was false when it was made. It remains false to this day. But the fact that it was uttered as a complaint tells me that the information was received by Council Member Mendoza Navarro from a former council person outside the context of a city council meeting. And we assume you all are acting in accordance with the press, because it is quite indicative of reasons on which you base a potential action of the city or a vote. And if you base a vote something that amounts to a personal reason, or perhaps even out of a desire to advance the agenda of a former council person, have a conflict of interest because this is a quasi-administrative, and we have a council member vote basis of a personal reason as opposed to interest of the city of Selma. That council person has a clear conflict of interest. And the ensuing vote, no matter what it is, rendered invalid by virtue of that council member's participation. So in my considered opinion, and I've been providing city council's opinions on conflicts of interest that disqualify their participation for the last 35 years. And in my considered opinion, Councilmember Mendoza Navarro has expressed our personal reasons, not reasons that have anything to do with the city or the city's interests. This is perhaps the clearest case I've ever seen of a conflict of interest. And if a vote is taken, I have no doubt that dissenting members would proceed to get a court to intervene and determine that the council member was in fact disqualified, taken invalid. The consequences of that run the gamut from simple fines imposed by the FPPC, civil liability for the city, civil liability for the council person involved, and in the worst case scenario, criminal prosecution. So I would advise and I would urge Council Member Mendoza Navarro qualify herself from participation in the one agenda item have the full detail of what I'm expressing to you is set out in a 3-page memorandum that I've issued to all of you. And I would refer you to that for further details because I'm not allowed to express those details.
Okay, with that, I will reiterate the question. Any council member has a potential conflict of interest may announce the item now and recuse themselves from discussing and voting on the matter. Any council member has any comment on what they heard? That we will move on. Right? With that, we'll move on to oral communications. During public comments, if you wish to address the City Council, under Government Code Section 54954-3.3a, you may only address the City Council concerning any item that has been described in the notice or the special meeting. Members of the public shall limit their remarks to 3 minutes. Do we have any oral communications tonight?
Hi, caller ending in 021. Your line is open. Please use *6 to unmute your line. Do you have any comments for council? And may I have your name for the record? Caller ending in 021. Your line is open. Please use *6 to unmute your line. Mr. Tutelian, your line is open.
Okay,
You have
Can-
3 minutes, and for the record, please state your name.
can you hear me?
We can, thank you. You have
My
3
name-
minutes.
The Honorable Council, Mr. Mayor, my name is Cliff Tutelian. I am the general partner in Selma Development Partners. And for the since 2006, we have been working with the city, and I'm going to go back in history for a minute. And I want to say that it's a travesty that amongst newly elected members, there's an immediate conflict that's brought before the public against an individual who is the most knowledgeable of the depth of background, legally, logistically, and even financially, because all the legal documents relate to the finances of the city. And having undertaken the oath and the responsibility to the public, it just is mind-boggling how such a conflict can arise so quickly and so soon. It is apparent, in my opinion, that it is political. And that's the sad part. Politics before the good of the city, and to defend and uphold your oath of office to protect and defend the city. You've turned on somebody that I can tell you, and from my experience in the last 15 years, that this man, without his involvement and without his background, the city will face significant difficulties and financial impact. I went off the screen, and am I still being heard?
Yes.
Okay, so that was confusing. It just came back on. Thank you. And with that comment, I'd like to point something out. In 2018, an interim city manager came on, and pursuant to the departure of one of your Selma citizens who acted as city manager. And that person, that individual, in a very short period of time, acted and took many actions without the acquiescence and approval of the council. And it resulted in one that I know of, a $700,000 expense that resulted from misguided counsel from a lawyer that was hired without being vetted by the council. And I will tell you that I've had firsthand knowledge, because I've been at the council hearings, as for the police station. The misguided counseling received at that time, I can attest, and being a developer, I can explain to you in detail how and why it cost the city of Selma an extra $3 to $4 million because of political maneuvering.
Mr. Tutelian, give me 1 second. Your 3 minutes are up. If you'd like more
Mr.
time,
Mayor,
you have to ask the mayor.
Mr.
Because
Mayor,
it's a special meeting and we only have probably a few speakers tonight, if with the council's indulgence, I'm going to let the speakers take a little more than 3 minutes. Is that okay with everybody? Is that okay with you, Pat? Hey, are you pretty close to wrapping it up, Mr. Tutelian?
I just need another minute or two.
Is that okay?
I think
We have
this-
consensus. Thank you.
Thank And I appreciate that, because this involves a very important relationship in dealing with a project that's going to create many, many jobs and have a significant positive impact on the city. Thank you for allowing me to continue, Mr. Mayor and council. I want to get back to the point. I firsthand understood and observed how that interim city manager took actions without properly following the city charter. It resulted in added expenses and it resulted in delays. And I'm not asking you to believe me, I'm asking you to research it and take it under careful consideration. At the time, the planning manager with 22 years of background to planning, he quit because he was run off, and it's common knowledge amongst those that were there at the time. And at the same time, it was maneuvered, and this Mr. Constanzo, with all the background and the history of your bonds and development and infrastructure and all your transactional knowledge that require legal counsel that guides you, that amongst the many, many litigations that the city's been involved with, has had, from my knowledge, let's say a 250 to 2. Bear in mind, his job is to advise the council on their action, not defend them with 100% guarantee when they're wrong. Right now, you are being faced with a decision where you're going to lose the person that has the significant background. Now I'm going to relate it to the public park. I've been working on a plan that I know you're going to be very, very pleased with. The plan was based on information of the past. And when I asked for verification of boundaries to proceed with the final stages of our plan, and I guarantee you, ladies and gentlemen, you will be more than happy with the plan. I found out that the configuration placed in the application and the configuration is totally unusable, will most likely trigger some CEQA requirements because it's adjacent to and contiguous to a federal land reserve.
Thanks, Mr. Titelli. We're going to have to move on after this, but thank you for your comments. Much appreciated. Do we have any additional oral communications this evening?
Mr. Avalos, your line is open. Please unmute your line if you have comments for council.
Yes, I do. This is Mr. Jim Avalos. And you just heard it from a developer, you know, how important it is. Yeah, and even when I left the podium that night and Varl took my place and also, what's the name, new person on the council, Bev Cho, 2 new council people. And when I made my statement, before I left, how important it was, we're under this, you know, COVID-19 situation and the pandemic situation, how important it was to keep all staff, you know, engineering, attorneys, all members in the city working because of the history of the knowledge that's going to take place and get it done in a manner that they all know the players involved. Like Mr. Cliff says, if you don't, you know, when you have somebody new, it takes a while to develop that relationship. And right now, under the pandemic situation right now, you have to move forward with the city of Selma. This requires a streamlined operation to know the players of what's going, how to get it done right away. That's in a state, federal, and county level. If you don't know these situations getting done, you're gonna put the city back financially, and you're gonna put hardship in our community. When you do the hardship in our community, that's blame on the council. You as the council leaders, you have to show responsibility because you took an oath to serve the public. You have to learn to do that wisely, very smartly. And under this situation right now, you have to carry on what is going on. And it's very important right now, guys. Is if you lose one moment of delay, this costs the city of Selma money and projects. This is very serious. Business is opening up and everything. This is not just the city of Selma, the surrounding cities as well, working together, cooperation together in the valley. You're gonna need this. State, federal money. You're gonna know who's who. If you don't, you won't get those money, you won't get those funds or the grants. This is a serious matter right now, guys. And this is on your guys' watch. Whatever you guys do is gonna fall on you guys for the city of Selma. And that's all I got to say. Thank you very much.
Thank you for your comment.
Caller ending in 521, your line is open. Do you have any comments for council? As a reminder, please use *6 to unmute your line.
Yes, Raina, can you hear me?
Yes, thank you. May I have your name for the record?
Yes, Yolanda Torres.
Yolanda Torres, you have 3 minutes. Thank you.
Okay. Okay. Ms. Navarro, understand that you cannot go in and fire a city attorney without valid cause. I understand if one does something illegal, which would cause grounds for immediate termination. But just because you dislike someone or this is a personal vendetta followed by somebody else that just left city council is absolutely wrong. You are making this a personal issue, which has no place in this forum. Understand that. This city has been through so much, and you promised us you were going to sit there and you were going to do your job for the citizens and move this city forward. When you get in that position, you need time to go in and do your homework as far as getting updates on all the contracts, business ventures, incoming proposals from businesses, etc. You're telling me you have had the time to find an issue with our city attorney? No, you haven't. This is nothing but a continued vendetta from a past city council member, and we all know who that is. You were voted in to move this city, again, in the right direction. And that is not happening. RFP, if you don't know what that means, request for proposal, needs to be submitted for other attorneys to apply to our city, which then goes through an interview process, which can take months. During that time, our city cannot be without representation. These steep steps need to be done. This takes time. How can you be so irresponsible, newly coming into that city council, and leave our city open for lawsuits and especially no representation? We have so many contracts pending and need our attorney who has been working on them and moving our city in the right direction. Ms. Navarro, the $4.1 million grant expires in 2024, which is just around the block. You obviously don't have the experience to understand that this project takes years. Our current attorney, who has 20 plus years experience, has been helping moving this project forward, but not just this project, many others we have pending. You have to understand, Ms. Navarro, that you are putting us in a very critical situation. You are going to halt our city, our revenue, and keep businesses from coming into our city. We finally felt that we had a city council in place that was going to move our city forward, not halt it or move it backward. I am so disappointed, as well as many other city members, that you feel you can come in and blindside us and make an irresponsible decision. This is crucial to our city, our citizens, our businesses, and our revenue. Understand that citizens are not happy, and we will take action needed to protect our city if you are not going to do so.
Thank you very much for your comments, Yolanda. Much appreciated.
Thank you.
Hi, caller ending in 379. Your line is open. As a reminder, if you have comments, please use *6 to unmute your line. Do you have any comments for council?
Council Clerk?
Hi, can you state your name?
Yes, my name is Humberto Gomez Jr., Dr. Humberto Gomez Jr.
Thank you. You have 3 minutes.
Yes, good evening, council members. As you know, I'm a resident of Parlier, but I grew up in Selma. I've known Blanca Mendoza since I was in diapers. And it's apparent the level of intimidation that she's gotten. And I'm tremendously disappointed. I will definitely, as far as the city attorney, I'll talk to other attorneys. Ms. Mendoza Navarro does not have a conflict of interest. The city attorney works at the behest of the city council. The city council has the right to fire and hire the city attorney for whatever reasons. There doesn't need to be due cause. There doesn't need to be any type of breaking of laws. So to me, the voters have spoken. Mayor, congratulations. You know, Ms. Cho, congratulations. Ms. Blanca Navarro, it's time to stop the political intimidation and to move the city forward. And to move the city forward, I've been disappointed because guess what? I find a conflict that the city attorney works for Blanca Navarro. When have you stood up, Mr. City Attorney, to explain to her that guess what? This is a situation. The recounts that I've been disappointed with Councilman Avalos, who I've known tremendously, who I've even stood up as a child at picket lines. I'm disappointed, Mr. Avalos, because you have tried to intimidate Ms. Navarro. And I will not allow to stand for this. I will not allow for her to be stigmatized, for the council or anybody. If they talk bad about Mr. Mayor Robertson, I stand up for him. If they talk about Mr. Trujillo, I stand up for him. There's 3 women on the council now. And this is the thing. Women get things done. Please, for all the sake, let's stop this movement. Let's move forward. The council decides whether they want to keep the city attorney or not. But no, Ms. Blanca Mendoza Navarro does not have a conflict of interest. I've checked with attorneys. She does not. Stop the intimidation, Mr. City Attorney. I would suggest that you go ahead and move forward and win your argument in another way instead of by intimidation, instead of by these tactics that you have used. So please, look, you do a good job, but please
Thank you, Mr.
go ahead
Gomez.
and
We
make your
appreciate
argument
comments.
based upon that. Mayor Robertson, take the mantle, get this thing together. Let's work together to
Caller ending in 021, your line is open. Do you have any comments for council? As a reminder, please use *6 to unmute your line. Mayor Robertson, those are all the callers that we have.
Thank you. Okay. That I will go into this helpful script from the city's employment practices contract attorney and say that the council placed a matter on today's closed session agenda for public employee discipline dismissal release under the Brown Act of Government Code, Section 54957, Subdivision B1. Also pursuant to the Brown Act Government Code, Section 54957, Subdivision B2, the individual in question was given notice that this matter had been placed on the closed session agenda of a regular meeting scheduled for today, and an opportunity to request that this matter instead be heard in open session during the time period on the agenda dedicated to open meeting, public comment on closed session items. I've been informed that the individual requested that the matter be heard in open session. Mr. Costanzo, is that correct?
That is correct.
Okay, in that event, the matter will be heard at this time. Before we begin, I will take a few minutes to explain the process that we will use to conduct this open session item under the Brown Act. An employee may request that complaints and charges be heard in open session. When such a request is made, we are required to hear in open session the complaints or charges that we would otherwise have heard in closed session. Therefore, we will hear from the city's administration on the factual basis for the city's recommendation in open session. The employee will then have an opportunity to speak. That will end the public consideration of the matter. Any members of the public who wish to speak on this matter may then speak, subject to the council's usual procedures for hearing public comment. We've already heard public comment, so that matter may be irrelevant at this point unless someone wants to call back. Which case we will have public comment subject to the same guidelines that we had oral communications under. After public comment, the council will move to closed session for deliberations. The council will make its decision in closed session. City manager, please proceed.
Thank you, Mr. Mayor, members of council. The city has an interim agreement with Costanzo and Associates for special counsel services. The city is considering terminating the agreement pursuant to the terms of the agreement. Section 9 of the agreement termination states, this agreement may be terminated by the city at any time without notice, without cause, and/or for any reason. Thank you, Mayor, council members.
Thank you. Mr. Costanzo, would you like to address the council?
Absolutely.
Please begin.
A truly stunning agenda. Member of the public looking at this would probably think that one of your employees had been arrested for doing something like storming into the Capitol building, and that you needed to immediately get this on a special meeting agenda to get rid of the clear and present danger of that employee. You'd also probably conclude that the mayor was asleep at the wheel because the mayor did not call the special meeting as is his right and obligation. Instead, we have a special meeting set by 3 council members. That turns out obviously not to be the case, because with the agenda, I received the 24-hour notice, which, Mr. Mayor, I'm going to be asking you make an official part of the record of this proceeding so that there's no misunderstanding about what's going on here. And so that it's a public record. And so that there's no misunderstanding that there is absolutely no need acting in such manner. In fact, you can see by looking at your agenda for 12/7 that this very same agenda item was just a resetting of the same item that you had on for closed session and on that date, on December 7th, which the council emerged and reported that it had taken no action on the item. Given the abrupt resetting of the same agenda item, one would expect that something truly earth-shaking had occurred in the ensuing 6 weeks relative to my attorney-client relationship. But that isn't the case, because I have had absolutely no interaction with any of the 3 council members that have taken the extraordinary step, never occurred in this city, voting to have a special meeting with this. So I frankly just don't understand the urgency of requiring a special meeting, which is merely 2 business days before your regular meeting. The 24-hour notice I received does not amount to the 24-hour notice that is actually required by Government Code Section 54957B2, because it does not disclose the charges that you are considering, although it does in fact confirm that you are considering charges. And as a result, any action you take at this meeting will, in the words of that subdivision of that section, be null and void. Giving notice of a hearing or a right to a hearing on charges is absolutely and utterly meaningless unless the person you're addressing the notice to is apprised of the charges and the evidence supporting them, so that the evidence can be rebutted, explained, or tested. That is just basic due process of law. So since you have not issued the notice required by the statute, not go into closed session as the script provided to you by your personnel attorney states. So I will also ask the mayor to make my response to that notice part of the official record of this proceeding, so that it's clear to the public what is transpiring here. While I have not received notice of what the charges or complaints are, I am aware that complaints about me were in fact discussed in your closed session meeting on December 7th. So I am led to the inescapable conclusion that this is just a continuation of that meeting, and that the complaints you are asking me to address are the complaints that were made at that time. You all received a memo from me before this, and you've hopefully had an opportunity to review that, because believe it or not, it is not my desire to be embarrassing people or making accusations against people or disclosing in an open session what was discussed in a closed session. But the law simply does not allow you to discuss complaints made against me without first providing the proper notice. So since this is not allowed to be done in closed session, there simply was no privilege or confidentiality that attached session discussions. Regardless of that, I respect the council's expectations of privacy for their discussions in closed session, and I'm not about to close what was said in any closed session, despite the accusations of your personnel. So I will do this in the most general manner possible, unless, of course, the two council members that raised those complaints in closed session are actually willing to disclose those. And of course, hearing none, I will proceed to answer the complaints that were made without disclosing what those actually were. One of the complaints is by the new council person who has no personal knowledge of me, what it is I do, what it is I've done in the past. And the complaint is the broadest conclusion one can actually make about what trial attorneys typically refer to as their track record. So of course, the only possible way in which a member could come to that conclusion when the member is not aware of the lawsuits that I've handled and their outcomes is by what that member has heard from other people. I will simply note that it is a very, very familiar complaint to me, and I have a very good idea of where it came from. I also know very well that it's absolutely and utterly false. And since the communication did not occur in the setting of a public meeting, it's slanderous. Being a lawyer, very much inclined just so that you know what the truth is. I've been practicing law for 35 years. For the first 15 years of that, I was exclusively a trial attorney. I've tried more than 85 jury trials to verdict. Most lawyers don't get that far in 40 years. Started working for Selma in 1989. And at that point, until about 1996, all I did was handle your cases. Lawsuits brought by you, lawsuits brought against you. After 1996, I assumed a more city attorney-like role. My partner was, I acted as your assistant city attorney from that point until about 2003, when he became incapacitated and I took over as city attorney. Ultimately, the council appointed me city attorney in 2007. Long and the short of it is that I have handled more than 250 cases for this city. And I've lost a grand total, 2 cases. Now, as you would expect, with respect to any case that is brought against the city or is brought by the city that I have handled, I have sat down and spoke with the council and specifically about the likelihood of success or failure before case is dealt with. With respect to the 2 cases that I lost, the council clearly expected to lose both cases because they were made aware of the fact that they would likely lose or answered or filed. But one of those was a single case in a group of 4 cases, all of them by the same plaintiff, Consolidated Irrigation District. All of the cases except for one were CEQA cases. First one was a case that challenged a mitigated negative declaration. And of course, with respect to a mitigated negative declaration, you are fighting an uphill battle in defending that mitigated negative declaration because all anybody has to do is make a legitimate argument that you have not mitigated all of the potential environmental impacts. So the council knew very well going into that case what the outcome was likely to be. Their hand was forced, however, because CID challenged every project. They had a total of 4 suits, 3 of which, or 2 of which were cases that involved projects on which you are. One of those was Mr. Tutelian's project. That one went to the Court of Appeal. We won. And at that point, the other 2 cases simply went away because CID came to the city and offered a settlement, which, as it turns out, best thing that's ever happened to this. There is a current new law, groundwater mitigation law. You look around you, you will see that every city out there is paying CID or whatever irrigation district has control over their territory more than $400 per acre foot of water, surface water, to be transferred into ponding basins and other groundwater recharge facilities that will allow you to comply with that new law. In your case, you have an agreement with CID, which they can't terminate, which they'd very much like to terminate, until at least April 15 of 2025, where they collect from Cal Water approximately $110 per acre foot of water pumped by Cal Water. You acquired Rockwell Pond. You acquired the ability to use CID's valves to receive surface water free of charge. That will exist until at least April 15, 2025. And literally, that all turned out for a much better position than you would otherwise be. The second case was a adventurous case. It was against Kingsburg and LAFCO. Basically, the city filed that knowing that it was an adventurous case. They were likely to lose. But they felt they had little chance of getting the same kind of treatment that the county was according to Kingsburg, did not file it. Ultimately, you ended up losing that, but lost it by a hair. And in the Court of Appeal, Court of Appeal ordered that all the parties were to bear their own costs and fees. Typically, in those kinds of cases, required to pay the other side's attorney's fees. So the council went into that case knowing that it would likely not be successful. And they came out of it getting the favorable treatment of Kingsburg over Selma stopped, and to this day, more favorable treatment of this city than most in this county, including Kingsburg. There's a third case that I suspect you are being told that I lost, but I didn't lose it. The city council terminated my contract on June. I had a trial set for July 13, 2018, in a case against the Department of Finance relative to the Pollution Act, redevelopment agencies, before a judge who was a Harvard grad, and I requested a statement of decision, and I moved, and he found the case was complex. And he issued an order to that effect, which is something that they do when they want to take an extended amount of time to decide the case. Otherwise, they have to decide it within 90 days. You then had your new city attorney substitute in on that case. Day after that substitution was filed, this Harvard-educated judge issued a highly, highly deficient decision that did not amount to a statement of decision type required by law. And he served that not on your new city attorney who was by that time attorney of record. He served it on me. I, of course, had to pass that along to your new city attorney because I had been substituted out. And I told your new essentially, that was a message to me, get back in the case, which I attempted to convey to your new city attorney. And your new city attorney, I'm told, came through and said, there's just no way. Case, there's nothing you can do. He's issued a final decision. When any competent litigator would tell you, what you do is you simply file objections to the deficient decision issued, and he, the judge, set a hearing and take the matter back under consideration. Typically, that has the effect. New city attorney was not interested in that, and so you paid $711,000 that you should. So I didn't lose that case. You lost that case. You will recall, and this goes to the second complaint that Mr. Avalos placed on your agenda point in September of 20, a evaluation attorney. Her response to that was to resign and abandon her client. I wasn't involved in that. I didn't know it had occurred. I have no doubt that Mr. Avalos did that as a prelude, attempting to terminate her and getting me back. Because by the time he had seen what he had done, what this new city attorney had done to the city, he realized the city was incurring liabilities, $711,000. Worst possible thing I've ever seen a city council do, city attorney do, advise you that a labor agreement that purportedly required you to issue a request for bids, include the payment of union wages, enforceable agreement that you couldn't get out of there is a public contract. And we call it the Bay Bridge provision. It's there because the city of San Francisco wanted to require the payment of union wages on their project. And they were getting sued because the contract plainly not enforceable. There's no consideration for the contract. The union isn't promising to do anything. Contract was subject to being rescinded or simply ignored. Yet they told you that you had to include that in your bid proposal and you had to pay union wages. The mayor tried to get the council to rescind that agreement, but 3 members voted not to, included in the bid proposal. That cost you about $4 million, unnecessarily. During the period between June of 2018 and September of 2019, this county, huge building boom, huge building boom. Take a look at Clovis, go take a look at Parlier. A huge building boom, but your city attorney went and told David Seremian and Larry Raven, who had obtained approval of a loan for $4 million to install a sewer line that would go out to Golden State and allow for development of the portion directly north of you, which is currently undeveloped. And Seremian were both told by this city attorney that they had to pay prevailing wages in order for them to build a sewer line and dedicate it to the city, which again is nonsense. Mr. Tutelian went away, didn't come back. I'm simply pointing these things out to you because I'm fairly sure that none of you really have much experience hiring attorneys or evaluating but you can see what kind of disastrous, pick the wrong one. There isn't a person, as Mr. Tutelian pointed out, has more institutional knowledge. interim city manager that you brought in for a reason. And that was to give a sweetheart deal to a development that's never going to occur, Selma Crossings, and to diminish prospects of Mr. Tatelian developing the commercial development right here next to Rockwell Pond and your future park, if you get it. With respect to your future park, I think you realize just how easy it would be I don't want to see that happen to this city. I spent too much time and effort on this city. I want to see this city succeed. This city stands at the crossroads of 99 and 43. This city should rightfully be larger and more prosperous than the city of Clovis. And it could be very easily. So I would just urge you to consider those things and consider instead of some promised retribution, real interest in this city. Thank you, Mr. Mayor.
Thank you, Mr. Costanzo. So having heard that, the council may now ask any clarifying questions. We'll start with Council Member Mendoza Navarro. Do you have any clarifying questions for Mr. Costanzo? Council Member Trujillo. Council Member Guerra. Mayor Pro Tem Joe. I have a question for Mr. Costanzo. What is the role of a city attorney in cities that have had a generational turnover, such as Selma, where there is a lack of institutional knowledge, where the city attorney has that knowledge? What is the role of the city attorney in terms of guidance, and what is the significance of that role, in your opinion?
Well, and probably special district in and several in the next county. I am very familiar with everybody that you. I'm very familiar with your board. I am very familiar with everybody. I am very familiar. All deputy attorney generals that work in this area, because what I do, and every lawsuit that gets filed against one of my clients, typically the person is the Attorney General's office. In fact, I just got 3 published decisions. Case against, in 4 cases against the Regional Water Quality Control Board, where I've successfully dismantled their entire method of operation to find. I'm familiar with everybody in this city who matters in terms of your city's development and revenue. I'm very familiar with your top sales tax producer. I handled probably 7 lawsuits against the guy. And we know each other well, times, but we share his information with you through me. That is very, very useful because the guy basically built that side of town, everything in it. So, I mean, there are things like understanding how it is you're going to have to deal with your traffic issues, particularly as it relates to Floral Avenue there. Development of Mr. Tertullian's project and your park. And, you know, Mr. Nelson is very, very knowledgeable about how to go about doing that, and knowledge that he attempts to share with his council. And I don't think sometimes it really sinks in, because to understand what he's really talking about, you got to go out, drive the dirt road that he's talking about, which I do. All of your developers out here, including Mr. Seremian, and I'm very familiar with the one attorney who represents all of them. Every developer out there is represented by a guy named Bruce Brown, who I've been dealing with for 35 years. So I don't know if I've answered your question, Mr. Mayor.
You have. Thank you, Mr. Costanzo. I have one final question for you. Has any attorney firm approached you to ask for your files as the replacement or the successor attorney to the city attorney for the city of Selma?
No.
Thank you for your response. With that, we will ask for any further public comments. Has anyone stayed on the phone and is wishing to make a public comment? Need a break?
Hi, caller ending in 021. Your line is open. Do you have any comments for council at this time? As a reminder, please use *6 to unmute your line. Hi, Mr. Tertullian. I see that you have your hand raised. Do you have any comments for council at this time?
Yes. Are you able to hear me?
Yes.
Yes, we can hear you fine.
Thank you. Thank you for the opportunity to comment. I've listened to the testimony tonight, and I just want to offer this, ladies and gentlemen. You have a lot of opportunity before you, and much of the testimony that you've heard tonight, I hope, is a reminder of the risks that are taken in replacing council, irrespective of their talent or knowledge, because the background that you have is so important, because your planning staff, and there's been so much turnover in the last 2 to 3 years. The project that I'm involved with is going to create many, many jobs, a significant amount of tax base, and the manner in which we're laying out, and I'm looking forward to presenting it to you, the cooperation that you will have in moving the legal issues forward between the county, the funding, the avoidance of CEQA issues, the guidance and avoidance of the Federal Wildlife Reserve, where the original configuration was laid out, there's complications that you don't know about. It'll cost thousands and thousands of dollars to bring somebody up to speed. And if it is true that this is politically driven, think about the welfare and the being of the city in terms of the needed income. Think about moving the city forward for the growth and the betterment of creation of jobs and new tax base. And the redundant expenses in getting somebody acquainted. What Mr. Costanzo described to you was incompetency. But even if you could, through an appropriate vetting process, it's going to cost thousands of dollars. And irrespective, from my own experience with a legal background and in development, irrespective of the dollars and the intelligence of a replacement, nobody, I haven't heard anything that gives rise to justification of spending all those fees to start over. If you had a good reason, then that's something to talk about. But the man, by virtue of his knowledge and therefore the economic value of what is referred to as institutional knowledge, I hope you would recognize as a significant value from the job creation and tax-based generation.
Italian, thank you very much for your comments. We appreciate it. Do we have any more public comment? Anyone wishing to make a public comment at this time?
Yes, caller ending in 521. Your line is unmuted. Did you have comments for council? Okay. Caller ending in 021.
Raina, can you hear me?
Hi, yes.
Okay, this is Yolanda Torres. I'm just sitting here listening to everything, and I just can't believe what is happening. I just really don't. I just know that our city attorney spoke, and I think he clearly laid it out on the table. So I don't see where this is coming from, only that it's a personal issue, which doesn't, like I said, belong on this forum. Council members were voted in to move us in the right direction, not to cost us money, not to cost us a lawsuit, not to cost us projects to be held, jobs to be held because of your personal agendas. So I hope you bring that under consideration before you make this irresponsible decision. That's all I have to say. I'm disgusted right now at what's happening with our new council. Thank you.
Ms. Torres. Are there any other comments?
Caller ending in 379. Your line is open. As a reminder, please use *6. Do you have any comments for council at this time?
Yes, I do. Thank you, County Clerk. Thank you, members of the council. My name is Dr. Humberto Gomez Jr. I just want you to look initially what the city attorney attempted to do. He attempted to recuse a council member for the purposes to keep his job. For me, I work in the regulatory field, deal with many attorneys. It says a lot right there that can be considered a conflict of interest. I want the city to move forward, but also you have to look within yourself. Who is causing the divide? Who is igniting the divide within our city? When I was there for the redistricting plan, and I know we spoke Mayor Robertson, who initially put out the plan? Who initially put the plan out that helped you get elected? I think my father made that statement, from what I recall. It wasn't the city attorney. Please don't pay attention to the scare tactics. I've heard many of them before. that you'll lose money, that the lawsuits, that this or that. If the city of Selma should have been such as the city of Clovis, well, look in the mirror. How long has the city attorney been there? That's what's at stake now. You have the capability and the judgment, and if you want to keep them, fine, keep them. But you also have the ability to make your judgments and your decisions based upon many other qualified candidates that could do wonderful jobs in terms of grants, in terms of bringing a medical center to the city of Selma. That is my dream. And I'll tell you what, I promise that I will help that. Because in the middle of the COVID-19 pandemic, we could see that we need jobs, we need educational opportunities, but also please stop the divide. Look at who's dividing for the purposes of their own gain. Look what's going on. I know all of you well. I respect all of you. I might have differences, but guess what? At the end of the day, I want the city of Selma to be successful. I want all you guys to be successful. And I get pissed. I'm sorry it was kind of heated before, but I get upset specifically when I feel the intimidation tactics are targeted to a member, a Latina, specifically because she got elected. The city spoke. So thank you very much, council members. Please, I pray that you guys make the greatest decision. Let's move the city forward. Let's make the decision for the possible city of Selma.
Thanks for your
And
comments.
please do
Dr.
not pay
Gomez, we
attention to the
appreciate
scare
it.
tactics. Thank you, Mayor.
Thank you. Do we have any other comments?
Hi, caller ending in 453. Your line is open. Do you have any comments for council? Please state your name for the record. Hi, caller ending
Hello,
in-
can you hear me?
Yes, thank you. May I have your name for the record?
This is Rosemary Alanis.
Ms. Allen,
Can you
have
hear me?
3 minutes. Yes, thank you. You have 3 minutes.
I'm here because I support Blanca and Bev, and I believe what you guys are doing is right, correct. Please do not succumb to the intimidation, the bullying. I would also like to know, I just don't understand. I'm surprised here because on the post on Facebook, we were told to listen, call in, listen, watch this because you guys were going to terminate the attorney. I didn't believe it. I come on here and this is what's going on. How did that person know ahead of time that this was going to happen? I'm just dumbfounded. Please, you guys, come together, do the right thing. We have new ideas, new faces on the city council. Work together and don't bully.
Thank you for your comments.
Hi, Mr. Avalos. I see you're still on the line. Do you have any comments for council at this time? As a reminder, please use *6 to unmute your line if you have comments. Mayor Robertson, I have no further comments on the line.
Thank you. That will conclude this hearing on this matter. We will then move into closed session. However, we've had a request from City Attorney Costanzo to hear this matter in open session. I've been advised by the attorneys to leave that this matter is up to the council to decide whether the next phase is in closed or open session. Do we have a consensus to put this next matter where we deliberate and take the vote, which will then become a public vote coming back? Do we have a consensus on whether this will be heard in open or closed session? Please step up to the mic, and Shailene will follow up with you.
Excuse me, whether you're allowed to go into closed session is determined by Government Code Section 54957, Subdivision B. We've been focused, and I believe you're directive from your personnel attorney is focused purely on subdivision B2. You have to read a statute in the context in which it is written. Subdivision B1 states that this chapter, the entire law, the Brown Act, shall not be construed to prevent the legislative body of a local agency from holding closed session during a regular or special meeting to consider what you're considering here, the discipline or dismissal of public employee, or to hear complaints or charges brought against the employee, unless the employee requests a public session. So that is the governing language. It is not.
And you're requesting a public session, is that correct?
I believe you are required, because I have requested a public session. The statute tells you you can go into closed session unless the employee requests a public session. This couldn't be clearer. The language of subdivision 2 is much more convoluted. And it says, as a condition to holding a closed session on specific complaints or charges, you must give the 24 hours notice of the charges. Which did not occur. So I just think by a clear reading of the statute, that a closed session is prohibited by the statute because the person that you are considering charges against, as you've acknowledged in what is a very inartfully drafted letter or 24-hour notice, that you're considering charges. And I've made the request, and by the plain language of the statute, you're not allowed to go into closed session if that request is made.
Thank you for letting us know that, Ms. Bennett. Do you have a retort to that, please? Or your opinion?
Can I sit here?
Please, as long as you have a mic for the record.
Okay. Mayor and council, if you have any specific charges or complaints, those must be heard in open session. We disagree on the law. You can go into closed session to deliberate, but if you have any specific complaints or charges, those must be in open session. You then, as your mayor has already indicated, have the option of going into closed session to deliberate if you want, if you so choose. Otherwise, if you do not need to deliberate and there are no specific complaints and charges, then you can proceed with open session.
Okay. Just so I understand that, we can go into closed session if the council so chooses, and if there are specific charges or complaints, they would have to be brought back out to open session.
They must be in open session.
Must be in open
They
session.
are not to be in closed session.
So what's the purpose of closed session?
If there's anything else that the council wants to deliberate on other than bringing up any specific charges or complaints, those
And
must
that
be
is a
stated
majority,
now.
that's a decision of the majority of council, is that correct? Whether to go into closed session, or even if one person has anything they want to discuss in closed session. Does anyone have anything they would like to discuss in closed session?
No.
No? Okay. Anyone? Okay, in that case, we would move forward with deliberations in public. I think we will take a 5-minute break because we've been here for a while, and then we will come back and move forward with open deliberations and a vote.
I would just note that it would be proper for deliberations to be in closed session. But if
Didn't we
you're,
just, but
that it's proper for deliberations to be in closed session. It's any complaints or charges, do not take them into closed. They're here.
okay, we'll take a 5-minute break and then we will go into closed session.
Go to closed session?
I would, no, we just adjourn into close, into. With that, we will reconvene. And now we will adjourn into closed session. And then we will come back and announce the vote after the closed session. Thank you.